Hello, everyone. Thank you for joining us today. As we wait for everyone to shuffle in, we will begin momentarily in a minute or two. Thank you.
Good morning, ladies and gentlemen. Diversity is hot. More than once, companies struggle with this topic and how to prevent a diversity policy from ending up on the shelf as a paper tiger. This webinar discusses the importance and the legal framework of diversity and will give you some takeaways in respect of items you have to discuss either on an operational level or on a strategic level related to the diversity policy putting in place. I'm aware that this topic might raise some questions on your end, and you can ask them by completing the Q&A box at the right upper end of your screen. Your panel today is composed of Anne Kamp, and our special guest, we have Tim van Cannaert, who will talk us about an item which is inextricably linked to diversity. This is privacy. And myself, and I have the honor to start and set the scene of the legal framework, the hurdles, to point some attention elements, and how to draft a policy. But first of all, let's see, what do we mean by diversity and inclusiveness? If you look at the dictionary, it defines diversity as variety, variation, the phenomenon that somewhere there are people with different ethnic or cultural backgrounds. Most people think of diversity in business as more women in top positions, but it is way broader than that. It concerns all characteristics in which differences may exist, such as ethnicity, lifestyle, culture, age, religion. All these elements are backed by diversity. It's inextricably linked to inclusiveness. Without the open mind, openness, commitment, and the empathy that inclusiveness entails, diversity has no chance. In other words, inclusiveness is the application of a diversity policy, engagement in practice. The legal texts are very varied and scattered around. You will not find them, or you will not find a code, one code in respect of diversity legislation. Discrimination, of course, equal treatment legislation in a nutshell, it is treating in equal circumstances people equally. Now, we're talking about CBA 25, equal remuneration man-women. It is an old collective bargaining agreement, which is to be part of your workers' regulations. The Discrimination Act based on EU directives, and will later on be more going into detail. The Act of 2014 on sexism, on handicap 2009. But diversity can also contain some aspects of recruitment, selection, and well-being at work. It is also linked to those, or to that legislation. Collective Bargaining Agreement 38 specifies very clearly the process an employer and the rules an employer needs to follow in respect of recruitment, and also addresses clearly the fact no discriminations or discrimination can take place at that stage. The Act of the 4th of August 1996 in respect of process putting in place harassment of employees. Code of Well-being provides that the employer must carry out a psychosocial risk analysis, can be related to stress, burnout, and that can then be related because someone doesn't feel comfortable at the workplace, because diversity is not being respected, or he is being targeted, harassed, etc. And at least once a year, that policy or that psychosocial risk analysis needs to be discussed, needs to be transparent with the employees. So also these elements will come into play, that legislation. Action plan, I will come back to later to that. Social dialogue. If you want to put in place your diversity policy as an annex to your workers' regulations, because you want to also add some sanctions to the application and enforceability of your diversity policy, well, if you have a work council, then that work council will have to be consulted, will have to be involved. Collective bargaining agreement number 5 says that whenever there is an individual complaint, the union delegation can provide for assistance. And then of course, the Committee for Wellbeing at Work, well, that committee, Prevention and Wellbeing at Work, will also be involved to verify whether the employer complies indeed with the policy, the diversity policy, and complies with other means, like, for instance, setting up, providing with deep psychosocial risk analysis. So you see quite a large number of legislation which comes into play. Now, diversity and promotion may sometimes come in conflict with equal treatment. I already stated the legislation. There are 19 grounds of discrimination. That means that based on these grounds, whenever there is a distinction based on these grounds, that constitutes a prohibit discrimination. It means, when, in other terms, whenever you're going to treat someone in a not equal way in equal circumstances based on these grounds, it will constitute a discrimination. Now, there are some exceptions, and justification can be based on objective reasons, a legitimate purpose, and proportionate means to achieve the pursued objective. Nevertheless, if we look at the diversity policy and the items important for a diversity policy, we see that the legislation even put forward a stricter protection of the grounds of discrimination, like, for instance, race, skin, color, ethnic origin, etc. The legislator put in place a more specific legislation in that respect, that you have to provide, or you have to be able to demonstrate that you make that distinction because of a decisive professional requirement. Only then you will be able to make a distinction. Furthermore, even in this range of criteria, you have differences. For gender, for instance, it's a closed system, and you can only make a distinction based on, in the cultural sector, for a mannequin, for a model, for painter. In other words, whenever you need a woman to be painted, you will choose a woman, and you have a good reason to choose a woman. Whenever in a play someone of color needs to be playing a role, well, you will be able to choose someone of color. So quite important, and certainly important in respect of the diversity policy. Now, that's why, indeed, sometimes it can be useful to provide for some exemptions by law and some positive action, so to speak. And there will be no discrimination when a distinction on the legal grounds involves a measure of positive action. Now, it needs to be stressed that there are quite a number of conditions which have to be fulfilled. First of all, how are you going to implement it? By collective labor agreement or by an act of adhesion, a toetredingsakte, acte d'adhésion. You will need the approval by the Ministry of Work. And furthermore, your plan will have to comply with a number of conditions. There must exist a state of manifest inequality, and that is going to be a problem later on with the privacy legislation. Tim will comment on that. How are you going to determine that there is a manifest inequality on the basis of color, on the basis of sexual preference, on the basis of religion? How are you going to bring the data together? Elimination of this inequality must be identified as an objective of the company, a strategy. It must be clearly defined. It must be temporary, maximum 3 years, so that plan may be put in place only for a maximum period of 3 years. And it must be proportional, meaning adequate and necessary, and it may not restrain the rights of others. We could even conclude here that quota are not allowed based on this rule. As I said, legislation on privacy will then be equally important just to determine and to gather the data. So diversity and addressing discrimination, diversity, even I would say all the aspects related or to the 19 grounds, well, it's even important before the employment starts. And so some tips: avoid some neutral selection criteria, but seem to be neutral, like have a good presence in a back office, for instance, 4 languages for a cleaning lady. Expand on recruitment channels, not only in newspapers, which are read by white male, for instance. Flexibility in planning of the recruitment interview, not on a Friday, no separate list of man, women, race. And we have been commenting and assisting some companies who have very large recruitment offices, just to be able to see that whenever they have recruiters, they don't go into a discrimination area or might be presumed discriminating. So it's very important to be very accurate on that and to follow that up very closely. What can be asked? Well, elements about previous jobs, about studies, but not being pregnant, or the medical situation. Even if you go as an interviewer too far, well, into the privacy of the employee or future employee, the future employee can lie and it cannot be held against him or her. Now, why should you have a diversity policy at your workplace? Of course, you will read a lot of reasons about increased creativity, etc. But from a legal perspective, it's about avoiding claims for discrimination. Not only claims, but nullity of some clauses, to pay damages, an action to stop before a judge of the discriminatory acts, and even sometimes the publication of a judgment which will cause detriment to your image as a company. So first of all, well-being at the workplace, well, it is indeed to be legally compliant, to have that assessment of the psychosocial risks. And as I was mentioning, the ambient harassment, where without being targeted directly, the victim is subject to provocations, obscene and vulgar jokes, which become unbearable, which is also seen as a psychosocial risk at the end. Well, to identify those, to address those, and to put an action plan to avoid those in future. So these are also to be compliant with that legislation which could lead to quite some severe penalties and even criminal sanctions. Responsibility of the employer. I'm stating here 2 cases before the European Court of Justice where homophobic statements have been made by an employee, and the employer stating was also pursued The employer stating, well, he did it, because it was a man, he did it in his own name. He didn't have the power to link the company, but the European Court of Justice decided otherwise and stated that there was a link between the employee and the organization, the association, and the recruitment policy. So even if the person doesn't have the power to link the company, it is an association with the company. So the company is also responsible. In one case, even the employer stated that the employers, I'm lost it, but so the coaching and the information will be very important. It came back to me in one of the first case law. The company even stated, well, look, it's not us. We haven't said it, but the Court of Justice stated that they didn't distantiate themselves enough from the statements of the employee, so there was a link, so they had also responsibility to bear. The image of the company, public statement that the employer will not recruit employees of a certain ethnic origin was considered as a direct discrimination, a presumption of a direct discriminatory recruitment policy, and the company had to show that it didn't discriminate, and a diversity policy would help or could help some. And then also to avoid some claims of employees, some claims justifying the reasons for a termination of employment. We have had already the cases whenever the termination of an employment is being considered unreasonable, also a claim for discrimination is being launched parallel to challenging the reasons for discrimination. There, this diversity policy and the fact it has been implemented, stated, can certainly help. Harassment claims at the workplace, and of course, coming up, whistleblower, we think that also whenever there is an act or an omission which is unlawful, discriminatory, for instance, based on legislation of the European Union, also the whistleblower will have some empowerment. What should be the content of the policy? I will not go through all of these. I think it's important that you address and to determine to whom it will apply, employee, third parties, that you put a reasonable adjustment process, a complaint process, and even eventually some advice and supporting groups that you mentioned them by name, which can be of an additional help to the company, and of course provide for some training. How are you going to implement it? Well, it depends on the enforceability you want to give to the policy. It can be a specific policy, it can be inserted in a code of conduct, it can be a charter. We have seen that already whenever we have been commenting or advising on. A charter is a document which is signed by employee and employer. But of course, one of the other elements is that it becomes part of the work regulations. And it can also be enforced by sanctions which are provided for whenever the work regulations are not being complied with. And Anne is going to go deeper in what you can do with those work regulations, what you can put in the work regulations in the frame of a diversity policy. So Anne, without hesitating, I share and give you the floor for the second part.
Okay. Thank you, Stefan. Good morning or good afternoon, everybody. So from my part, I will particularly dig into the topic of company neutrality policies, and I will more particularly examine the question whether an exclusive neutrality policy is legal or not. Stephanie, if you could give me the mouse. Thank you. So a lot of companies have an exclusive neutrality policy in their work regulations, such as the clause you're seeing now. So it's a clause whereby, in fact, the employees have the prohibition to manifest in any way, either verbally or in their clothing, any religious, philosophical, or political conviction. So they are not allowed to wear any symbol of religious or political conviction. And so the question is whether is such a clause valid or not. And it's rather actual because it has been in the press recently as a result of a recent court decision of the Brussels Labour Court. But before, I think it's important to examine and summarize the legal framework. Stefan has already spoken about it, but it's important to know that we have the legislation at a European level. We have several directives that the member states must transpose in their national legislation. And in Belgium, it's rather particular because you have on the one hand the federal level legislation and on the other hand the regional level legislation. And it's important to know that the regions in Belgium have their own power to legislate so that the regional legislation has the same value as the federal legislation. At European level, we have a lot of directives regarding equal treatment and anti-discrimination. I summarized here the three main ones. So we have a directive concerning the principle of equal treatment between persons irrespective of racial or ethnic origin. We have the directive providing a general framework for equal treatment in employment and occupation. So that's an important directive. And a third one is a directive on the implementation of the principle of equal opportunities and equal treatment of men and women in the matters of employment and occupation. So each time you will have an issue, you will have to find out which directive is applicable. On federal level, Stefan has already mentioned the two anti-discrimination law. We have also the law of 81 on racism and xenophobia. I will not repeat it. And then you have that regional level legislation. There are too many decrees or ordinances to provide a summary here. But you must know that you have the decrees of the Flemish community, of the French community and the Walloon region, as well as the ordinances of the Brussels capital region. And some decrees and ordinances are only applicable to the private sector, some only on the public sector, and some both on the private or public sector. So it's important to really find out which is the strict legal framework you have to work within when there is an issue, for example, in your company regarding the discrimination. So I thought it was interesting to remind you of the notions of direct and indirect discrimination before going further. Stefan has already explained what is direct discrimination. So we have a distinction made between the employees or an applicant based on a protected criteria. So normally, for example, if as an employer you say, okay, I want only hire employees with a healthy back. So that's a prohibited criterion. It is a direct discrimination on the basis of health, but it is not a discrimination if the distinction is justified. If you are saying that you will only hire employees with a healthy back because you are looking for someone who can be active in to handle luggage in an airport terminal, of course, it is justified by an essential and determining professional requirement, and so it is not discriminating. It's also legitimate and also proportionate because you're not imposing any other condition as far as the health is concerned. And then we have the indirect discrimination. That is when we have a situation where you have an apparently neutral criterion, but when you apply it, it is disadvantaging a group of persons in comparison with another group of persons. And there is a presumption of discrimination, but if it can be justified by a legitimate goal, and if it's appropriate and necessary, then it will not be considered as discrimination or as an indirect discrimination. Just a little example: if you as employer, you decide to only grant variable remuneration to the employees who are employed full-time, okay, it's apparently neutral. But if only the women in your company are working part-time, of course, when you apply it, it results in a discrimination between men and women. So there is a presumption of discrimination, and in this case, it will indeed be indirect discrimination because it has not a legitimate goal, because you cannot handle employees employed on a full-time and a part-time basis in a different way by application of the Belgian labor law. So what's now the current status of the case law? Because to find out whether the exclusive neutrality policy is legal or not, we must look at the case law, and first at the case law of the European Court of Justice, who has already had a lot of opportunities to rule about that. But the landmark decision is the Ashbita decision. And in that case, it was the case of a Muslim woman who was wearing the Islamic headscarf and who had been applying for a job with GS Secure Solution. So a potential employer who had an exclusive neutrality policy that was applicable for employees of the front office, so in contact with the clientele, and G4S did not accept the application of the woman because she did not agree to abide with the exclusive neutrality policy. And so the question was, yes, is this a direct discrimination, such an exclusive neutrality policy, or can it be considered as an exclusive, as an indirect discrimination? And what has the European Court of Justice ruled? That is that the prohibition on wearing an Islamic headscarf that is resulting from an internal rule of a private company that prohibits the visible wearing of any political, philosophical, or religious sign in the workplace does not constitute a direct discrimination based on religion or belief, provided, so there is a condition, the rule, the policy may not target in particular a specific religion. So the neutrality policy may, for example, not target only the Muslim religion, and it has to be applied consistently and systematically. This means that if a Muslim woman is not allowed to wear an Islamic headscarf, then, for example, the Jewish men cannot wear a kippah, a Sikh will not be allowed to wear a turban, and the other employees will not be allowed to come to the office with a political slogan on their shirts. On the other hand, the European Court of Justice ruled that such an internal neutrality rule does even not constitute an indirect discrimination, even if in the facts it resulted in a particular disadvantage for person adhering to a particular religion or belief. So even if it affects more particularly the Muslim religion as such, it's not an indirect discrimination, provided here also conditions. It has been justified by a legitimate goal, and the means to achieve the goal are appropriate and necessary. So the question is now what must be considered as a legitimate goal. In the Ashbita case, the Court of Justice only gives an example. It says it's just such as the pursuit by the employer. So it's a legitimate goal for the employer to want to be neutral towards its clientele or towards its customers. So that's a legitimate goal, and it's appropriate if, for example, as in this case, the ban is only applicable to employees of the front office. However, the Court of Justice did not answer whether you can also apply such an exclusive neutrality policy for employees that have only a back office function, and whether, for example, you want to apply such a policy within the company to every employee because you want to guarantee the social peace. You can imagine a company with a very diverse personnel and with tensions amongst the personnel regarding those diversity. You could imagine that some employees want to apply a neutrality policy to ensure the social peace within the company. But so as such, today, there is no case law in that respect. So we cannot be sure that it is a legitimate goal. So we have that very clear, in fact, case law of the European Court of Justice, but recently the French Brussels Labour Court asked a new question to the European Court. In fact, it's a request for the fine-tuning of the existent Ashbita case, and the rule has asked again, in fact, to the European Commission whether such an exclusive neutrality policy cannot be considered as a direct discrimination on the grounds of religion, and on the other hand, if it cannot be considered as an indirect discrimination on the basis of gender, because it prohibits, in fact, the wearing of an Islamic veil, but not an Islamic beard, and so it would be an indirect discrimination based on the gender. So we do not yet have an answer to those questions, but it is this very same judge who ruled the recent case that involved the STIP. It's the public transport company in the Brussels capital region. STIP is the main employer in Brussels, and was condemned for discrimination by ordinance of 3 May 2021. Here, what was the legal framework? We have here the public sector. We have to apply the specific legislation applicable in the Brussels capital region to the public sector. And among others, you have an ordinance that's aiming at promoting diversity and combating discrimination in the Brussels capital region in the public service. So the judge has taken into account this very specific ordinance to rule the case. And what did he rule? And that's quite new. He anticipated, in fact, the answers he asked to the European Court, because he said, yes, there is here a presumption of direct discrimination on the basis of religion. Why? Because we have Article 9.1 of the European Convention on Human Rights that provides for a freedom of religion. So by applying such a ban of wearing of religious symbol, there is a presumption of direct discrimination. And the STIP, the judge has noticed that the STIP could not justify the discrimination on the basis of an essential professional requirement, and so it holds direct discrimination on the basis of religion. So in the head of the STIP, and moreover, the judge decided that there was a presumption of indirect discrimination on the basis of gender, as already told. So he says, yes, if you compare the group of women to which the plaintiff belongs, and it's the women of Muslim women wearing an Islamic headscarf, if you compare it with the Muslim men wear a conviction sign being the bird, if you look at the situation of the woman, it appears that if the woman would not have been a woman but a man, then she would not have been affected by the disputed measure, because the men can in principle wear a beret, even if it is the symbol, even if it can be the symbol of a religious conviction. And the judge decided that the STIP could not produce or explain the distinction on the basis of a legitimate justification. Maybe, and I've almost finished, a little word about intersectional discrimination. You read a lot about intersectional discrimination in the doctrine. Today, that's not a notion that is covered by the law, nor at European level, nor at national level. But it's and it was invoked in the recent STIP case. So the plaintiff invoked that as such, maybe there was no discrimination on the basis of the religion, and as such, there was no discrimination on the basis of gender. But if you combined both criterions, then you must notice that in the facts, the neutrality policy disadvantages more particularly Muslim women. And so the combination of those two protected criterions results in an intersectional discrimination, but that has not been held by the judge because it was not necessary, because it already held the direct discrimination on the basis of religion. In a nutshell, to conclude, so if you want to apply within your company an exclusive neutrality policy, in the current state of the case law, if you are a private company, be careful, and we can only advise so far, and waiting for other case law, to limit it to employees of the front office in contact with clientele, to provide it in writing, for example, in the work regulations, to also support the neutrality policy, not only in your work regulations, but to also incorporate it in your corporate values or in a mission statement. And of course, as I told you, please then be aware and be careful that the policy in practice is always applied in a general, consistent, and non-differentiated way. Thank you for your attention. And now I give the floor to Tim, who will more particularly tell you the GDPR aspects of diversity.
Thank you very much, Anne. So if we could go to the next slide, please. What Anne and Stefan explained, I think no one will contest that D&I policies are great and important, but obviously if you don't implement a mechanism to measure your diversity and inclusiveness baseline and the evolution, you're unable to tell how successful you are in achieving that objective, of course. So you need data to measure your success, and in this case, obviously, it will be data of your workforce, which is personal data. And that's why we need to say a few words about data protection as well. Now, there's a few complicating factors when we talk about D&I, and the first one is that the data that you are collecting will typically be so-called sensitive data. I think except perhaps for gender data, all D&I data will constitute special categories of data in accordance with Article 9 of the GDPR. So basically it's data that reveals racial or ethnic origin, religious or philosophical beliefs, like Anne mentioned, also the health condition of people, if they have disabilities or not, sexual orientation, etc. Now, as you hopefully know, processing special categories of data presents a higher risk or even a high risk, and I will come back to that in more detail in my next slides. But so it means that you need to be particularly careful. The second complicating factor is the fact that we have very limited data protection authority guidance around processing of data in the context of D&I. And to the best of my knowledge, there's currently no enforcement decision issued by any DPA in Europe, which might teach us what is acceptable and what is not. So in a way, you might say that as important as it is from a societal point of view, diversity and inclusiveness policies, from a data protection point of view, it's a bit of a minefield. Now, clients often tell us, well, don't worry, we only process anonymous data, so we shouldn't care about GDPR, should we? And the answer, as it is most of the cases, most of the times the case in life, it's more nuanced than that. Indeed, they're correct in saying that the processing of anonymous data falls outside of the scope of GDPR, but and I'm stressing this, the threshold for anonymous data is very high. It means data is only anonymous if it is no longer possible to identify or re-identify the individual. So it has to be irreversible. And in practice, it's not easy to achieve that. So imagine that you ask employees to complete a survey. You don't ask for any direct identifiers like their name. Then you could potentially consider the responses in the survey to be anonymous data, but bear in mind that if this is an electronic survey, it may still be possible that you can identify the individuals based on electronic identifiers linked to their computer. And obviously, if you work with anonymous data, practically speaking, your data set will be less useful when you want to start analyzing the data. So what happens a lot is that companies trying in an attempt to increase the practical use of the data, they will ask some general questions. Perhaps not the actual age, but at least the age group, not the title of the individual, but the department that they're working in, etc., etc. And on the basis of these responses, they will then aggregate the data and create statistics. And the question here is, does this constitute anonymous data? My answer would be, it's very likely that it's not anonymous data. It's almost certainly not anonymous data before you start aggregating. So at the time that when you receive the responses, then it will likely constitute personal data. And bear in mind, the act of anonymizing data constitutes processing of personal data as such. But even after the aggregation, for smaller organizations which only have a few people in certain departments, it may well be that you're still able to single out the individual based on those generic questions that you asked. So the key takeaway, I would say, is that in most cases, you will be processing personal data when you conduct DNI service, and so you need to comply with the GDPR. Now, if we go to the next slide, let's have a look at what it means in practice. And I think the first thing that you need to assess is always whether you are able to rely on a lawful ground for data processing. Since we're talking here about special categories of data, you should mostly look at Article 9 of the GDPR. And the general principle of Article 9 is that processing of special categories of data is prohibited. You're not allowed to do it unless you are able to rely on one of the exemptions listed in that article. But they're exemptions, so they must be interpreted restrictively. In the context of DNI, we think that basically there's three exemptions that might be relevant. The first one would be reliance on explicit consent of the employee. It's explicit consent here, which means that the threshold for reaching it is higher than the usual unambiguous consent that you need to get when you're not dealing with special categories of data. So it's quite difficult to achieve. But also the question here is, are you able to rely on consent in an employment context? You probably all know that because of the hierarchical relation, the regulators tend to say that consent is almost never possible in an employment context, and that it should be avoided as much as possible. And of course, here in this context, especially in a recruitment context, I would say it is tricky because the individual might fear that if he or she doesn't provide the information, that might negatively impact the decision that you make on recruitment. So it has to be freely given, otherwise it will not be valid. So given those complicating factors, ideally you would like to rely on another exemption, and that could perhaps be a legal obligation as an employer to conduct DNI service. The other good alternative would be reliance on reasons of substantial public interest, but here again, they must be based on a law. So it's not enough that society at large considers that diversity and inclusiveness is an important topic. There must be a legal act by virtue of which you are authorized as employer to collect these kind of data for the context of your policy. And this is, for instance, what has happened in the UK, where they have equality of opportunity and treatment rules that authorize employers to collect this data. So Conclusion for this slide: whenever possible, try to rely on either the legal obligation or the legal authorization. And if those don't exist in the country where you're based, well, then go for consent, but make sure that it is freely given. If we go to the next slide, the real issue with this whole topic from a data protection point of view is that it's absolutely not harmonized. So it's impossible. You cannot adopt one approach across the board. You really have to look at national laws individually to see if they have these kind of laws. And in reality, not a lot of member states have adopted laws that either oblige you or authorize you to collect these kind of data. Anne mentioned the Belgian Act, the Discrimination Act. Well, the question is, can we rely on that as a lawful basis? The reality is that as the law stands today, it is considered not to provide a legal obligation or a basis of authorization to process these kind of special categories of data. The Belgian Data Protection Authority has taken the view that you should rely on explicit consent. But for instance, in France, it's the opposite. In France, the CNIL has decided that employers cannot rely on explicit consent. So here again, just an example of how much of a minefield it may be for multinationals. Okay, so moving on to the next slide. Once you've determined that you have one of those lawful grounds that you can rely on, obviously you need to look at the GDPR obligations more broadly. I tried to list the key attention points. Obviously, don't collect more data than you need. That's hopefully something which makes sense to you. You have to explain to the individuals what you are collecting and what you will do with the data, and you should not reuse that data for other purposes. Those are hopefully concepts that you're familiar with. They apply to all processing activities. And then more linked to the execution of your processing, there are a few points there. You have to conduct a DPIA because you will be processing special categories of personal data on a large scale. Obviously, security is an important point as well. I would say where feasible, aggregate or anonymize the data. Once you've collected it, that will reduce the risk. But if you need to re-identify the individual, then make at least sure that you pseudonymize the data. And don't keep the data longer than necessary. For instance, if you aggregate the data, ideally you should delete the initial survey responses as soon as possible, because then you don't need it any longer. That brings me to the last point, some practical tips that I wanted to briefly mention. So I mentioned the DPIA. I cannot overstate its importance. It will help you assess the risk and implement the surveys in a compliant manner, but also if you don't have a DPIA and the Data Protection Authority will start asking questions, obviously you are in trouble right from the outset, which you want to avoid. So yeah, the lawful ground, as I said, in Belgium, it should ideally be explicit consent, but bear in mind in other countries, it may be better to rely on the obligation or authorization by law. I think with regard to consent, as I said, make sure that people are under no coercion whatsoever. That's really the key point. I think you really have to do the effort of making it clear, very clear, that they're not obliged to reply and that not replying will not be held against them. And I think that is especially important in the context of recruitment. And it sort of ties together with the privacy notice. I think it really makes sense in the context of DNI to have a dedicated privacy notice just for this topic that you add to the survey so that people really know what it is that you will do, what their rights are, etc. That is very important. Aggregation, as I mentioned, I think really that is the best approach. I would advise people to avoid keeping the data on an individual basis. I don't think there's really a need to know that employee A or B has certain diversity characteristics. But if you do find a good justification for doing it, then at least make sure that this data is pseudonymized and restrict the access. I think only a handful of people should actually be able to access the data in the surveys, and only a handful. I mean, not even all HR professionals in your organization, but just the people who are really in charge of diversity and inclusiveness. Which means, in my view, that you should not be storing the responses to the survey in the regular employee file. Or if you're doing the survey in the context of recruitment, that it should be a separate stream. So the people who are in charge of deciding whether or not to hire someone should not even see the responses that the candidate gives to the survey. That should be ideally treated by a different department or a different group of people. And I think if you bear those in mind, that should take you a long way and substantially reduce your risk. With that, I hand over to you, Stefan.
Thank you, Anne and Tim. Well, I'm just going to conclude with a few words. That is that D&I is certainly on the agenda, a hot topic of HR functions, companies. It's also on the political agenda because I noticed a newspaper mentioning that one of the political parties would like to give a special premium for employers whenever they don't discriminate when recruiting staff. So certainly on the agenda, but as you have seen, it is a minefield. It is something which Tim and I and our team work together just to be able to be comprehensive and to light every issue which might be addressed or which has to be addressed in drafting such a D&I policy. Well, thank you very much for your attendance, and I invite you for the last one of this spring webinars on the 15th of July 2021 on travel time and working time, also a topic which is very hot on the agenda because of COVID, but also for other reasons. So thank you very much for your attendance and hope to see you next time. Thank you. Bye.